Good morning, everyone. I'm here today with Ken to host the Q&A. I'm going to start out with our initial disclosures to remind everyone that we are not here today to give legal advice. We are here to provide general legal information. And that being said, the chat function as well is intended only for questions and requests for clarification, commentary, and the chat is not to be considered legal advice either. Um, I do want to tell everyone to remember that we have the WSCAI annual conference coming up in April 9th and 10th. We will be there as well as Jennifer, one of our general legal attorneys, will be presenting that day. So we hope to see many of you in person there, since we mostly see you over Zoom these days. I am going to get started with the first question. The first question is, if multiple owners from the same unit would like to run for the board, is this something that can happen? The short answer to that question is yes, unless your governing documents prohibit this. To clarify, unless your governing documents state otherwise, there's nothing in the statute that restricts more than one unit owner per unit from running for the board. Furthermore, there's no reason to believe that no more than one unit owner of the same unit could not serve on the board as long as they were duly elected by the process. That being said, we don't recommend allowing this. And when we draft the bylaws, we typically prohibit that. I don't have without any more specific information about that question, that's the best way we can answer it. Ken, did you want to add anything to that?
No, you got it covered. So the second question is, does RCW 6490-535, which is a statute requiring a reserve account, and 6490-545, which is the statute that requires reserve studies, do they require, are those required for all common interest communities as of 2019? So the short answer is no and no. Section 535, which doesn't apply to all communities yet, but has similar language in the other statutes, is just about how money is held in reserves. The statute says that you're required to have a reserve account. It does not say that you're required to fund it. And it has nothing to do with whether you actually have a reserve study or not. Right? So even if you don't have a reserve study, the statute says you have to have a reserve account. We'll note that the budget disclosure process, which is section 525, that is applied to all communities since 2018. It does not require a reserve study either, but it does require that you state in your budget process whether or not there is a current reserve study. And if there's not, there's a statement you have to make. Okay. So back to section 535, it states that you must have a reserve account, but there's no penalty for failing to have a reserve account or failing to fund one. In fact, section RCW 6490-560 specifically states that you cannot have any penalty for the failure of the association officers or board members to establish a reserve account. Okay. Now, as to section 545, that's the one which is applied to all communities since 2019, and it does require a reserve study, but it has a specific list of exempt associations. And that list of exempt associations include non-residential communities. So if you're an association of commercial properties or boat slips, you would not be required to have a reserve study. It states that communities with, quote, only nominal reserve costs, end quote, are exempt. And of course, it doesn't define what nominal reserve costs are, but we can certainly imagine, if you were a townhome community or a single family community that had no common roads, no common parkways or parks, no common retention facilities for stormwater, that you may not have anything that requires maintenance that would qualify for a reserve study. And so you'd want to look at what your particular property is, but those are exempt. And then the third exemption is that if the reserve study costs more than 10% of your annual budget, you're not required to have one. It may still be prudent to have one, but you're not required to have one. And that's a very specific mathematical calculation. You get a quote for the reserve study. If it's more than 10% of your budget, you're not required to do it. So you want to add anything to that, Tima?
Nope, I think that covers it, Ken.
Okay.
The third question, is there a requirement to provide an absentee ballot for annual meetings in order to fulfill the board's election secret ballot for in-person meetings if there are also telephone and video options? And the second part of the question is, was the absentee provision just to satisfy the ability to vote before the advent of virtual meetings? So let's start by differentiating between absentee ballots and secret ballots in order to answer the question. The question regarding absentee ballots is that they are optional for all communities. The question as to whether the provision was to satisfy the ability to vote before the advent of virtual meetings, it's not clear the intent of the absentee ballot was to provide additional voting options outside of attending a meeting prior to the Zoom function or virtual meeting function. But we do know that the timeline is that the absentee ballot provisions were adopted for all communities in 2023. The secret ballot provision, which only is provided for in WUCIOA at 6490, was adopted a year later in 2024. So therefore, logic tells us the absentee ballot provision was probably not intended to address voting with secret ballots. Our position is that the legislative intent was most likely to increase ways for to reach quorum and to allow owners to vote. It's also worth mentioning that there are other valid reasons a person might not be able to attend an annual meeting virtually or in person. They might be sick, for example. And so while there's nothing in any of the statutes stating that absentee ballots are required, all of the statutory language suggests that they're considered a valid part of the voting process if they've been prepared and offered by the association. So to clarify about absentee ballots, which is the first question, unless there's a specific provision in the governing document stating that they're not allowed, then the association can use them. Alternatively stated, if the governing documents are silent on the subject, absentee and secret ballots are presumed valid. Therefore, our advice is that you continue to provide absentee ballots and secret ballots, obviously under WUCIOA as they're required, as long as they can be validated. When it comes to absentee ballots, if you want to prohibit the use of them, just don't provide them. And there are requirements for what absentee ballots are, what constitutes the validity of an absentee ballot under 6438 120 section 3D. Whenever proposals or board members are to be voted upon at a meeting, an owner may vote by a duly executed absentee ballot if, one, the name of each candidate and the text of each proposal to be voted upon are set forth in writing and contained in the notice of the meeting itself. And the requirement is the ballot is provided by the association for that specific purpose. It's also required that when an owner votes by absentee ballot, the association must be able to verify that the ballot was cast by the owner that has the right to do so. So under, for example, RCW 6490-455, section 2D, when an owner votes by absentee ballot under that section, the association must be able to verify. It specifically states that it has to be able to verify that it was that owner that sent in that absentee ballot. Let me see. Did I miss anything there, Ken? I think I covered
I think you covered it all.
Okay,
The couple things I'd comment on are you don't have to verify every ballot when it comes in. I think you can uh, verify if you had a close vote or you had ballots you didn't understand. I think that that would be a time you could verify after the fact. And then also that absentee ballots are not the same as secret ballots, which you started with. Even if you don't have absentee ballots, if you're a WUCIOA community, you would be required to use secret ballots for the election. And so you'd have to hand out ballots to the owners so they could fill them out. But those are not absentee ballots.
actually, I have a question, Ken. Would you assume is the presumption that the absentee ballot was cast by the unit owner and unless there's reason to believe that it wasn't?
Yes, that's what I would do. So
Okay,
if
that's
one
what I
owner
think.
were to walk in with 40 ballots, then it might be worth trying to verify those.
Right.
But if you're receiving them by mail from all the individual owners,
Yeah.
there's no reason to suspect that there would be any fraud.
Okay.
And also, if your results were 85% in favor or opposed to something, then there's less reason to go back and verify individual ballots because even if there were some that were uh, mistakenly added, meaning you may have gotten more than one for the same unit, or you couldn't verify that it was the owner who signed the ballot, it wouldn't make a difference for the results of your election.
Yeah, that's a good point. Okay.
So next question is says we're trying to determine if we can have exterior cameras for security purposes as long as the property is appropriately signed that such cameras are in place. So my shorter answer is as long as the governing documents don't prohibit cameras, that you can put cameras up anywhere that is in a public place. So you can have cameras looking at your, driveways, at the front entrance gate, at the cabana. Can't put them inside of restrooms, but you could put them, say, overlooking a swimming pool, because those are public places and there's no expectation of privacy, which is being infringed upon by the camera. Whether you have the signage or not is uh, not a determining factor. You might want to have signage because if you're trying to control people's behavior, signage will do it more than the cameras themselves. But in regards to common areas, the association would have pretty much no restrictions on their ability to put cameras into the common areas. There are laws which people have used to claim that you can't record an audio conversation if a person has an expectation of privacy. And it's true, there are laws about recording private conversations and that those require the consent of both parties. But there are no equivalent laws related to the photographs or video. And if it's outside in a public place, the expectation of privacy will not apply. And so the law against the audio recording will not apply either. So if you've got some specific location you're trying to put cameras in and you have a concern, it might be worth consulting with your attorney. But my general rule is that there's nothing to prohibit cameras for surveillance or security being installed in common areas. Anything you want to add, Tima?
Nope. I think that covers it, Ken. Question 5 pertains to RCW 6490 WUCIOA provision, which requires boards to allow drought-resistant landscaping. So more specifically, this is discussing RCW 6490, Section 512. Under Section 1A, the declaration of a common interest ownership and any governing documents adopted by an association may not prohibit the installation of drought-resistant landscaping, pollinator habitat, including beehives compliant with local regulation or what's called wildfire ignition drought-resistant landscaping. It goes on to say that the declaration and governing documents may include reasonable rules to restrict and govern these rules, as long as it doesn't render the use of drought-resistant landscaping effectively infeasible. Or so the question is, the specific question here that has been posed is, can a board deny an owner the right to cover their front yard entirely with clover? Clover has seeds that spread to other lawns and would become a nuisance. So we have to go back to the statute and ask ourselves, well, is clover likely considered quote unquote drought resistant landscaping under the definition of the statute? Of course, the statute doesn't define specifically what is drought resistant landscaping. We will get to a definition they do provide, but they don't provide that one. So, the question is, well, even if it did qualify, let's say it does, we believe that the intent was that that the legislative intent here, by providing some ability to restrict, is that the board can set standards for the appearance and maintenance of drought resistant landscaping. They could have an architectural review committee that has a policy that they could adopt that would create very specific rules about what is considered drought resistant and what types of materials could be used in this regard. Now, the second question is, can a board deny an owner the right to put artificial turf in the front yard? And if yes, can the board set a minimum standard for specifications of artificial turf? So the same statute applies. However, here we have the definition. Well, we have to ask ourselves again, does artificial turf appear to meet the definition of here what is most likely considered wildfire ignition resistant landscaping per the statute? The statute's intention was to reduce water use, and it was also intended to create a standard of reasonableness. So the question is, if you want to break it down, does artificial turf qualify as wildfire ignition resistant landscaping? The statute actually does address what is defined as wildfire ignition resistant landscaping under Section E. And under Section E1, it says any landscaping tools or techniques or non-invasive vegetation that do not readily ignite from a flame or otherwise ignition source qualifies, or the use of fire-wise methods to reduce ignition risk in a building ignition zone. So, even if it did qualify under the definition of the statute, we still believe the board can set standards for appearance and maintenance. And again, looking at the intent of the statute, it was to reduce water use and also to set a standard of reasonableness. So going back to what I said in the beginning, not the worst idea. We would definitely recommend, if this is something you are trying to actively regulate, adopt a policy that have the board adopt a policy that defines exactly what it feels is reasonable in terms of restricting the use of these materials. Ken, did you want to add to that?
Yeah, just a reminder that in the statute, it says the board can adopt rules as long as it does not prohibit the drought-resistant landscaping or fire-resistant landscaping. And so if you don't want clover, you just need to make sure there are some other reasonable drought-resistant landscaping that can be installed. So until we start having litigation over these things, we don't get anything more specific about what the legislature intended.
Have we even seen this yet specifically, Ken?
I have not seen
In
any
our office,
legislation on it.
Yeah.
We have some communities that have policies about the fire resistance, especially because we've had some communities up near Chelan and in Whatcom County that have been very concerned about the wildfires. And so we've helped them with policies to try and make the communities safer. That's not just with regards to what gets planted, but also with removing fuel that might spread a fire through a community. Next question. Our condo association has held monthly meetings in a clubhouse for 20 years. We've at times also used Zoom and the ability to listen to meetings with phones. Now the board has decided they will no longer meet in the clubhouse and will leave only the Zoom and phone options. We're a large community and there's a small number of homeowners who do not use or have computers at home. Do you have suggestions on how we may include all members of the association in meetings under these circumstances? So my short answer is that the legislature determined that Zoom meetings are fine, that you do not have to have meetings in person, as long as there's a telephone option to participate provided along with the Zoom platform. And we believe that the legislature basically recognized that not all community members have computers or are computer savvy, but that everybody has a telephone. And as long as you can provide an option that people can participate by phone, which means they can listen and that they can be heard when they comment during the section of the meeting where owners' comments are allowed, that you have met the legislative intent. It's not possible to accommodate every possible interest of a member to attend a meeting. So what you're trying to do is choose a method which is reasonable for the community and encourages participation. Anything you want to add, Kama?
Nope. I agree. And that's what the statute says, and that is what we recommend. So
Actually, there is a specific statute, which is 6490-445, subsection 3, D as in dog. And that particular statute now applies to every community in the state.
yes. The seventh question, do owners legally owe assessment to a condominium association that is not being run legally? Well, so the short answer is yes. And this applies not just to condominium, it applies to all associations. So I would say from the standpoint of a collection attorney who looks at governing documents related to this specific question all the time, I have yet to see a set of governing documents for any association that does not have a provision clearly stating that any failure of the association to adhere to any specific provision of the governing documents excuses an owner from paying assessments. Furthermore, and I won't go into multiple examples, but I can give you at least one example. The statutes all support this explicitly as well. For example, the statutes, since we were talking about reserve studies earlier in a question, the statutes all clearly state that a failure to have a reserve study does not provide an owner the ability to avoid paying assessments, for example. And that's stated in all of in RCW 6434, 6438, 6490. So yes, they still owe assessments. That's the short answer, and the longer answer also provided. Ken, did you want to add to that at all?
Well, I just always wonder, who's getting to decide whether or not it's been run legally.
Yeah,
Because until you've got a court order saying something has been done illegally, the requirement to pay assessments is going to stand, and only the court could decide what part of the assessments may not be required. And it usually would relate to how the budget's adopted more than anything else.
right, which would be a procedural question.
So next question, if I wanted to report what I believe to be illegal operation of a community association, where and how would I do it, and would it be beneficial? So my short first answer is there is no government agency that supervises or regulates community associations. There's also not any agency which supervises or regulates management companies for community associations. If you had an apartment house run by a real estate agent, it's regulated under the state of Washington. But a manager for a community association has no regulatory entity that you can report to. We've certainly seen people try reporting to the police and try reporting to the Attorney General's office. I don't think either of those are effective. I think that both of those entities are going to tell you that it's a quote civil matter and that you can use the courts. So if you believe that your association is doing something that's illegal, you have the ability in most communities to use the courts to have the court declare that some activity is illegal and require correction. Now, there are some community association documents where there are binding arbitration provisions which would prohibit you using the courts. And so you'd need to look at your governing documents to make sure that an arbitration provision is not going to prohibit use of the courts. It still has the obligation for the arbitration to follow Washington law. It's just that you would use a different procedure than the courts. As to whether or not it's beneficial, that's really a practical question. And part of the question is, well, why would you want to sue your association? If there are substantive procedural issues or failures to address requirements of the statute or the governing documents, we normally recommend you first try and approach the board and ask them to comply. And it may be that an attorney could assist you in that. But litigation is not usually a process which is going to generate harmonious working relationships. And so we would usually recommend that you try and work with your community to accomplish a worthwhile goal rather than start with litigation. We have a client where they had a pipe that leaked, and the association had to cut a hole in the wall of one of the units in order to patch the pipe. And the owner sued the association to have the wall repaired. And I'll say it just confused me because the association was willing to repair the wall, and we don't understand what benefit the owner was getting from actually filing a lawsuit to have a wall repaired for a cost that should have been under a couple $1,000s. And so there may be something going on we don't know about, but that ended up just being forwarded on to the insurance company for the association instead of being handled by our office. But, if you've got something which is, I guess it's a personal judgment on whether it's beneficial to you to try and file a claim against your association. Anything you want to add, Tama?
No, Ken. The next question is there a way to force a condominium association to be dismantled or terminated? First, I'll say, because when we refer to the statute refers to the word terminated, not dismantled. So I'm going to use that language. The short answer is no. It cannot be it can only be terminated by a vote of 80% of the owners under 6490, under WUCIOA, Section 290, or by a court under 6490-355. Just as there's a process to incorporate and create a community, there is a process to dissolve one, or to terminate one. The dissolution of a community association requires a membership vote in favor of so. Specifically, since this question is about a condominium, it deserves to be clearly stated here that when a condominium association is terminated, this effectuates all of the units to be merged back into a single piece of real estate, jointly owned by the quote unquote former owners. This, like I said, it merges all of the units into a single piece of property. So be aware that if the idea is that you're trying, and specifically, just be aware that that's not going to just it sounds like that's not going to effectuate what you're looking for here in any case. But just be aware of that. Also, if you're looking at a single family home community, they can vote to terminate the governing documents, the CCRs, as long as it's provided for in the CCRs. But that may or may not terminate the association. For example, as long as there's jointly owned property in the single family home community, one of the examples Ken and I were talking about was the stormwater retention pond, for example. You can't terminate the community as long as they're still jointly held property. So you might be able to terminate the governing documents, but you can't actually terminate the association itself. So again, it's not as clear as the question. The answer is not as clear as the question. And sort of back to what we said earlier in the previous question, I guess I'm asking myself while I'm reading this question, why are we asking this question to begin with? If there are concerns about the way that the association is being managed, if there are concerns about the board itself, I don't know in this particular circumstance, but again, the more practical first step would be to attempt to resolve these concerns before you were to take on and initiate the process of terminating the community entirely. It would seem to me that some of these issues might be handled through a competent association attorney who specializes in HOA and community law, and would be able to assist whether it's an owner or a board member with their concerns. As opposed to, like I said, going forward with this more extreme action here. Ken, did you want to add to that?
Yeah, for terminating or dissolving a condominium association, the only examples I've seen are where there's been either something like a fire which caused substantial damage, and so the property is terminated to be sold, or there was a community next to Children's Hospital in Seattle where the hospital wanted to expand, so they wanted to buy the piece of property. And the statute actually was revised to make it a 80% vote because they had some owners who had refused, but the 80% carried into WUCIOA, and it allowed for the condominium to be terminated. It became a single piece of real estate, which was then acquired by the hospital, and the courts distributed the money amongst the former owners. And that's one of the reasons why we don't see condos terminated, is that the distribution of the money is controlled by how the statute and the declaration are written, not necessarily by the fair market value or what someone has paid for their units. As to single family home communities, there are some plat communities where there are no common elements. We've got a number of clients where all the common elements were deeded over to the city or the county. So the retention ponds and the parks and open spaces, all the roads, they have been given over to the city. There's no reason for the association to manage them any longer. And there are legitimate cases where it may be that there's no need for an association any longer. Even if the CC&Rs are in place, the individual owners could enforce them independently against their neighbors if they wanted to. And so we have worked with a couple of communities who are looking to eliminate the associations in that manner. But again, you'd have to look at why was the association formed in the first place. The developer probably created it trying to provide for some uniform maintenance and look and feel for the community. And you just need to decide whether that's worth paying for, I guess. I've seen at least one community where more than half their budget ended up just going to administration and collection of fees to perform that administration. And I understood the frustration of the owners in their having to pay for that. But again, it was something which would require 80% of the owners to do. All right, so I think we're done with the questions that we received in advance. If there are questions in the chat, Chelsea, maybe you could tell us.
Yes. So first, a couple follow-up questions to the first question. Would there be any limits on their vote? referring to,
This is the more than one person
yeah,
from a unit serving on the board.
yeah.
So board members each have one equal vote. So if you were to have a husband and wife both serving on the board, each of those would get a vote. Now, the statutes don't allow for proxies to be used. So if only one of them showed up, only the one who showed up gets to vote. The communities often have variable votes for owners when owners vote on association matters, but that does not apply to board members. And if a community doesn't want to allow a husband and wife to serve on the board at the same time, they can certainly choose not to elect them. And that would be, my way of saying, well, if you don't like having the concentration of power in one unit, simply don't elect them to the board. Anything you want to add, Tima?
No, I think that's exactly what we kind of said earlier, but more clear. So, yeah.
Next, is there any responsibility on the owners to prove ownership?
So that's going to depend on the individual governing documents that you have. Typically, the Articles of Corporation or bylaws will state whether or not board members must be owners. And they are not required to be owners. Some documents will state that a majority of the board must be owners. Some will be silent about it, in which case you can elect whoever you want to be on the board. Some will state that you must be an owner. The statute does define owner to include members of LLCs or beneficiaries and trustees of trusts and partners and partnerships. So it starts to become a broader group of people than just an individual person on a deed. We do think that it's reasonable to have a way of confirming if a person is an owner. But that can be either because they're included on a deed, or if they are legally married under the community property laws of our state. If they are legally married and live in the unit, meaning they're using community assets to pay the monthly dues, then we would say they have a property interest that makes them an owner. But I guess I'd start to want to know the very specifics on why you're asking that question, and that starts to become legal advice on whether or not we think it's reasonable for you to start looking, or providing proof for owners. If they show up on the county records listed as one of the owners, we would usually take that as good enough. But I have seen governing documents, usually very old governing documents, which have stated that an owner had to provide proof in the form of a deed that they were an owner. You have any thoughts on that, Tima?
No, I think what you've said covers it to the extent that we can in this forum without knowing more about the question.
Our community was established in 1974. Are we required to follow all elements of WUCIOA RCW 6490?
Not yet, but starting on the 1st of January of 2028, WUCIOA will apply fully to your community.
And some provisions of WUCIOA already apply to your community. So it just depends on which provisions you're talking about.
Yeah, all of the meeting provisions in section 445 of WUCIOA, those apply as of January 1st this year.
And the budget provisions have been in place for some time.
Yes, since 2018. Chelsea?
If there are no nominations, then only items like minutes and resolutions can be voted on? Or can the ballot have a split duty as ballot and absentee ballot?
Well, this starts to be really specific, and I'm not sure what's being asked. It's possible to have a proxy form, which is submitted and serves only to count for a quorum for a meeting. I suppose it would be possible to use an absentee ballot, again, as defined in the statute, that an absentee ballot would certainly count towards a quorum, even if no voting was done with the absentee ballot, meaning if they just turned it in. If you're having an annual meeting without an election, then I don't know that you'd have any reason to put names or anything on the ballot. You might still have, an issue like agreeing to transfer any surplus assessments into reserves to comply with the IRS's tax requirements or tax code. You might still have approval of the meeting minutes from the prior meeting. Maybe you'd have, an amendment to the bylaws that you're trying to vote on. So I'm not sure I understand the question. Any thoughts, Tima?
I'm not sure either. I don't, I don't think I can elaborate beyond.
Can I asked the question. Can I just hop in real quick?
Sure.
The thought process I had on that is like if you have a absentee ballot and you have items like the IRS resolution or your annual meeting minutes, that could be constituted as a absentee ballot worthy items to vote on. But if you have not received any nominations for board members before the ballot goes out, could that have space for something like a write-in or a nomination to be something to that effect included in that ballot as well?
Well, if there could be an election at the meeting, whether you have nominations or not, I think the new statute requires you provide a blank space for owners to write in the name of someone they would like to elect. So it'd be the same as a write-in vote. And I think I would advise that you have to include that even if you have no prior nominations. So you just simply have a section on the absentee ballot for voting for board members and blank lines.
Okay, perfect. Thank you.
I assume at the meeting you'd actually accept nominations from the floor as well.
Yeah, absolutely. I was just more so curious if you could have, the absentee ballot would still function if there were basically blank lines on it.
I think it does. The legislature amended the law to require the blank spaces because somebody convinced them that ballots going out in advance of the meeting only listing the sort of board's selected candidates was somehow misleading or unfair. It would make people think they couldn't vote for anyone except those selected names. So the legislature said, no, you have to put a blank line in so an owner can vote for anyone they want.
That makes sense, and it's always challenging just to get nominees in general. So,
yes.
Agreed. Awesome. Thank you so much.
Anything else, Chelsea?
Yes. We have received proxies that were not sent to the secretary by the homeowner. Should these be verified if they have come through another party, not a part of the board?
Well, the statute does require that you be able to verify that the proxy has been submitted by the owner. And it says you have to be able to verify that the proxies, that the person listed on the proxy is correct. So we start to get back then to a question of scale. If you've got 3 or 4 of these proxies which are in question, but you've got 100 other votes which are adopting some kind of measure or, electing a board or ratifying a budget, I don't know that there's any need because the qualification or disqualification of those ballots will make no difference for the results. If it's a close election then I think it is reasonable for someone to telephone the owner and ask if they really did submit a proxy for the person that's named on the form. It really starts to be a measure of the circumstances under which you're receiving these. I think it's not reasonable to expect every single absentee ballot to have a follow-up phone call, especially if it's received via email from the email address of that you have on record, or it's received in a mailed envelope with the return address of the owner. So it's kind of a matter of having the ability to verify to make sure you don't have a rigged election, but that doesn't mean you have to assume every election is rigged when you start counting votes. I have a suspicion that all of the talk back in 2020 about the presidential election being stolen caused people to start wanting to make sure they could verify elections for their community associations.
Next question, camera clarification, please. Ring doorbell cameras at doors of condominiums, small building, so you can see all neighbors from these communities.
Well, I'm going to assume that the question is whether or not the board can regulate or prohibit. Getting back to what I think the legal standard is that the Ring camera is not a violation of someone's privacy because it is faced out into a public space. I think that a board which has the authority to regulate common spaces probably could regulate Ring cameras, but I'd want them to have some good reasons for doing that. I can tell you that the state of Utah actually passed a law that homeowner associations could not prohibit Ring cameras, and it was because of some event which occurred, and a homeowner was, couldn't have a Ring camera, so they opened their door and were attacked or something like that. So the question is, what kind of reasonable regulations are there? Is there some reason to suspect that the people with Ring cameras have some ulterior or nefarious motive? And if not, how do you just, I guess regulate both the appearance of the doors? Because I have some clients that object to Ring cameras because they change the uniform appearance of the front entry doors. And how do you balance the benefit that an owner gets from a Ring camera against the potential cost to the community and other neighbors? And I don't have a single answer for that. Any thoughts, Tima?
No, I just think we're not talking about a board. We're not talking about the community installing cameras here. We're talking about individual owners. So it's just a different question. But yeah, I think you'd have to have a pretty good reason for saying that it's a violation of privacy. So
yeah, if it was a Ring camera on a single family home or a townhouse where the boundary is not the interior walls, I'm not sure the association has the authority to regulate it. If it's a traditional condominium where the unit boundary is the interior side of the door, then the camera is mounted on the common areas, and it would probably be subject to rules and regulations by the board.
All right. Next question. If we use recorded meetings over Zoom and a person demands to receive a copy because they were recorded, are we obligated to provide it to them?
I'll say that's a good question and one I don't have a certain answer for. The question becomes whether or not that is a record of the association. The official record of the board meeting would be the minutes, which are ultimately approved by the board of directors at the next meeting. We would normally recommend that if it's being recorded, it be treated as a personal record of the board secretary, who would be using that to make sure that they had correctly written the minutes for approval by the board at the next meeting. But we have some clients that do record them and post the meetings, the full recording on a web portal. And I guess we haven't had a court case yet where a recorded version of a board meeting or association meeting was ruled on by the courts. If you're particularly concerned and don't want to let the documents be, or, let the recording be released, I would recommend you just don't record it. But it's a gray area, and we don't have anything yet from the legislature or the courts to tell us if I'll say privately recorded board or association meeting creates a record. The record section of the statutes, which are really detailed, do not address emails, and they do not address recording of meetings. Any thoughts, Dana?
Well, I guess I might ask why they wanted the recording, and if there was a question that could be answered, if it was a simple question, if there was if I'm presuming it's a homeowner that's asking for this, or the unit owner asking for the recording, it would be okay to ask, is there something specific that you're looking for here? Maybe I can answer your question, or, I'm not entirely sure why they're asking for it, but if it's something practical and simple, perhaps you might be able to satisfy the question without providing the record.
Yeah, if the reason a person gives is that they don't want to have to attend the meeting in person, which they have the legal right to do, I don't think you're required to make the recording available just because of that. We do have some clients that very intentionally have meetings that they record for specific purposes. So if you were trying to amend your declaration, or you were trying to support a special assessment for a large building project, you may want to have a meeting recorded where the different presentations from your consultants or questions from the owners are answered, and share that because you're trying to influence. And that is a way of providing information to help people make decisions. But that's different than just recording a standard board meeting.
How do policies differ from bylaws?
So I think we actually addressed this a couple of weeks ago, where we actually had different definitions for policies and rules and regulations and bylaws. So the bylaws are supposed to regulate the governance of a group of people. How does this association of people elect a board, make decisions? And a policy would be something which is going to provide finer detail about something. So, for example, you could have a policy on how the reserve funds are invested, or you can have a policy about collections or fine and enforcement. These are typically will detail procedures, and maybe they'll include things like monetary fines, which are adjusted at the discretion of the board and change over time. They have to be allowed by the bylaws and the declaration, and they cannot conflict with the declaration or the bylaws. There are some communities that have, I'll say, such poor bylaws and CC&Rs, or they're so old that they don't address the association's ability to adopt rules and regulations and fine owners for violations. But the statute trumps those documents, and it includes a specific authority for boards to adopt rules and regulations and to assess fines in accordance with a schedule which has been distributed to the owners. So if you've got something which you want to do on a regular basis, or you want to make it a more ministerial act by the board, you might adopt a policy. We've seen policies for electric vehicle chargers, heat pumps, reserves, policies for flooring replacement and other kinds of architectural control changes, policies about storage sheds. So the idea is to help give guidance to the board in its decision making so it can be consistent and meet the needs of the community. Did you have any thoughts, Tima, maybe specifically about collections policies?
I mean, I would just say that policies aren't required, but we often recommend them, and they provide transparency for owners and for the associations on both sides. And they can often be easier to understand for owners than going through their entire declaration or trying to understand the bylaws, which can be lengthy and cumbersome, can be lengthy and wordy, for example. So we often, as collection attorneys, for example, when I open a new file and I'm looking at a new client matter, I often review all the governing documents. I always review all the governing documents, but I look for anything specific to fine policies, collection policies, especially in light of the new laws in effect. These create a much clearer picture for specifically owners as to what their expectations are. And that could be, as far as what their duty to pay assessments, what the penalties are when they don't. And the same goes for fines and enforcement policies, for example. So like I said, we can't require them, but we often and very often recommend them.
I think we have time for one more, Chelsea.
Our bylaws require in-person annual meetings. Do we now have to add a virtual meeting option for the annual meeting?
I would have to see the exact language to know whether or not the statutes would allow an in-person or a Zoom meeting instead. Most governing documents are not so specific as to require a in-person meeting, but the statutes actually do allow for the documents to require in-person, and they can actually prohibit proxies and prohibit absentee ballots. I'm not sure why you'd want to do that, because you would be really limiting the ability of members to attend, but the statutes do not require, I believe, that you offer Zoom or other types of meetings. I think they allow rather than require, but I'd really want to see what the individual bylaws had to say.
And most governing documents wouldn't prohibit virtual meetings because they weren't necessarily envisioned at the time that governing documents were drafted, because virtual meetings are something that are relatively recent. So of course, a declaration that was drafted after COVID, for example, might have that provision, but I don't see that. I haven't seen it personally. Maybe you can.
Yeah, the only ones
I
I've
haven't seen one prohibiting it.
yeah, the only ones I've seen the last 10 years that were prohibiting proxies and absentee ballots were written by the developer who was trying to make it harder for the association to sue him. So I was reviewing one last week where if you wanted to initiate any litigation, you had to have 67% of the owners approve at a meeting in person where no proxies were allowed. And I thought it was an interesting way of the developer's attorney to try and make it difficult for the developer to be sued. But with that, I think we've run out of time. Thank you, everyone, for attending.
Thank you.
See you guys next week.
Have a great day, everyone. Thank you for joining us.